Justice Gorsuch agreed with the majority, but for a different reason. I agree with the court's judgment that the government examination of Okello Chaudhry's location history data amounted to a search for purposes of the Fourth Amendment. But respectively, I would reach that conclusion by a different route. It appears Justice Gorsuch's route is based on the definition of what a search is under the Fourth Amendment. To decide whether a Fourth Amendment search took place in this case, the court once again invokes a test first advanced in a solo concurrence in Katz v. United States. Under that test, a search occurs when the government intrudes on an expectation of privacy that society is prepared to recognize as reasonable. Surprise! The Supreme Court based its decision not on the Constitution or laws of the United States, but their own previous opinions. That precedent seems to be Justice Gorsuch's problem. The Fourth Amendment's protection do not depend on the breach of some abstract expectation of privacy whose contours are left to the judicial imagination. Instead, the Fourth Amendment speaks in more concrete terms, protecting an individual's person, houses, papers, and effects from unreasonable searches and seizures. No surprise, then, that it's hard to find anything like the Katz test in the law leading up to the Fourth Amendment's adoption, or anything much like it in the court's jurisprudence before 1960s. I'm glad to see that at least Justice Gorsuch sees that the term privacy does not exist in the Fourth Amendment. Rather, it's a question of when is a search reasonable. Now, rather than employ Katz and its third-party doctrine, I would take a different approach. To decide whether the Fourth Amendment is at play, I would consult its terms and ask first whether location history qualifies as one of Mr. Chaudhry's papers or effects, and then asking whether the government searched those papers or effects. The traditional approach remains very much part of our law. Indeed, we have expressly recognized that Katz and its progeny supplement rather than displace traditional Fourth Amendment principles. It's nice to see not just one, but two justices looking at a case based on the language of the Constitution, not just the opinion of their predecessors.